factual record that was before him. You can look at what he said, that there was absolutely no commerce nor any interstate activity in that case. Nevertheless, Justice Stevens, in his majority opinion, said, well, we can't allow this just because you say there's no interstate activity. There could be. Because he could, in his own mind, conceive something, he was willing to ignore the actual facts before him. I think that what we could really see is there was a bigger issue at play here, that he didn't want to eliminate the federal government's ability under the Commerce Clause to go into states and regulate activity there. Some of the so-called conservatives on the court wouldn't go along with our position simply because they hated drugs. You know, Justice Kennedy is a prime example of that. I don't think there is a legal argument at all, no matter how justifiable, that Justice Kennedy would be willing to agree to when it comes to anything that would lighten up medical cannabis or any drug. You know, one of the issues about this legal conflict that has been postulated if Prop 19 were to pass, similar to medical cannabis in California and the other states that allow it, is that under the Supremacy Clause, of course, the federal government would allegedly be able to assert its position as opposed to any of the states. But the fact is, what we have in the states with medical cannabis laws and what we would have with Prop 9 if it were to pass would not really be a positive conflict. An actual conflict would be if you were to pass a state law requiring people to use cannabis or to possess it. And of course, we don't have. There may be people who would support that, but that is not what the law would do. The states can have their own criminal laws, the federal government can have its own. The federal government may be able, unfortunately, to go into states and try to regulate what happens there. But the federal government has not had either the will or the resources to do that. What Prop 19 would really do is simply say it would not be illegal anymore to engage in certain activities. It doesn't even require the linchpin of doctors' recommendations, as Prop 215 does. What the feds, however, have tended to go after are not ordinary people who are just engaged in small-scale possession or cultivation, with a few exceptions. If you're engaged in that possession or cultivation on federal property, you know, a national park, a national forest, an army base, an Indian reservation, maybe then your small-scale operation would become a federal crime. Other than that, the federal government tends to only be concerned about what it considers egregious violations of federal law. In the worst year on record, calendar year 2007, what I call the reign of terror when it was happening, we had more federal raids on medical cannabis, dispensaries and gardens than any other year. According to ASA, there were only 57 such raids, or coordinated series of raids, in that particular year. At the time, there were 400 or 500 dispensaries and many more gardens at the time. So even in the worst year on record, the federal government could only hit a small number of people allegedly violating federal law. And since 2007, the number is reduced to merely a trickle. It hasn't completely stopped, unfortunately, but it's gone down to a trickle. Under our state laws, what we're really doing in California and hopefully other states with Prop 19 is similar to what New York did at the end of alcohol prohibition. You know, it said under this New York state laws, it would no longer be illegal to manufacture alcohol. It was then left to the federal government entirely. And the work that New York did at that time was really in conjunction with the Voluntary Committee of Lawyers. And I think that we're at a crossroads now where the Voluntary Committee of Lawyers can help achieve much the same result to the betterment of society for decades to come.
Not know away from so yeah, Governor Al Smith, 1931, Governor Al Smith signed a bill passed by the New York legislature saying it was no longer illegal. We're not going to enforce prohibition anymore. California, I suppose, would be doing the same thing. But and any of you who have questions or comments, please begin to line up at the microphone for the next 15 to 20 minutes. What's the risk? I'll ask you, what's the risk? Now, let's not say, because the next panel, we're probably going to talk about the risk of losing federal funding and so forth. Those are more practical questions. But legally, statutorily, constitutionally, if California passes Prop 19, what is the risk?
Well, it depends on, you've got to look at the constituency, and I come from the state of Maine, even though I'm not a Michigan professor, but I spent 30 years practicing in the state of Maine, and a law firm which I'm affiliated with, so I'm going to just talk to the risk to lawyers, if I can, okay? Can you hear me better now? The risk to lawyers. I am associated with a law firm that, Blue Blood is, as you can get in the state of Maine, 150 years old, one of the largest firms in the state of Maine, is very involved in the marijuana dispensary issue, and basically we get approached by, I think it was a California client who sets up these dispensaries. And so we went to the Ethics Council and said, okay, what's the scoop here? Can we help set up the corporate structure? Okay, because you need corporate lawyers on. The answer came back is, your own risk. And the opinion, which is dated July 7th, so it's kind of hot off the press, basically, and here's the bottom line, says, we can, however, state that participation in this endeavor, meaning assistance in setting up of these dispensaries or anything related to that, involves a significant degree of risk, which needs to be carefully evaluated. Now, what does that do? Well, I'll tell you what it did to this law firm. It said, thank you, but no. We're not going to get involved in this. So when you ask the question of the risk, I think you have to go identify the constituency. And for lawyers in at least several states, I think they're going to be faced with a real possibility of ethical sanctions, which, in all bars could mean loss of license. And so the question is how, cavalier is a lawyer going to be about putting his license at risk to represent a particular client?
I'll talk a little bit about the risk to Prop 19 itself in more depth, because, as I said, that I think that you can sort of look at it in two pieces. The criminalization piece, and then the piece of Prop 19 that allows counties or cities to enact, in essence, legalization, to have a tax and controlled distribution system. That, I think, is an area where it's plausible that it could be preempted, these county or city regulations. I still think it's unlikely, but I think that's going to be the sort of where the heat of the legal battle is, so to speak, over Prop 19. And if I was the federal government, I think probably the best approach to go after it would be to try and enjoin those city and county ordinances. When cities and counties pass ordinances under Prop 19, I would try and enjoin those, or maybe directly that aspect of Prop 19. And I think that's where sort of the big battle is going to be. I think the federal government's going to realize they're not really going to be able to make a plausible argument that the aspect that allows for legal possession and cultivation is preempted, but I think they will be able to make a plausible argument that the aspect that would allow for regulated sales is preempted. Ultimately, I don't think it would be a successful argument, but I think it's plausible enough they could press it in court, and I think it's plausible enough that they could potentially, depending on how they do it strategically, tie up the regulatory schemes for some time. If they convince somebody to issue a preliminary injunction to stop these county and city ordinances from going into effect, I can envision a situation in which the federal government is able, even if they don't ultimately win, to stop the sale, the tax and regulated aspect of Prop 19 from being implemented. I don't think that's likely. I think that they would succeed in it even in the short term, but that I think is the biggest risk to Prop 19. If you think about where is Prop 19 most in danger, I think it would be that aspect of it.
Let me throw again, though, that even with the personal cultivation and non-commercial exchanges, we already have the Supreme Court saying that that is a violation. I'm looking at the Controlled Substances Act here. You all know Section 903. I guess we're all a bunch of wonks up here, but and it's about the positive conflict. Unless there's a positive conflict between federal and state law, basically federal law rules. And I guess the decisions have been that anything that affects interstate commerce is going to be a violation. So I'm keep.
Well, I think that's not a, let me see if I can put your mind at ease a little bit on that. I think that it's a little bit apples and oranges to talk about the Kreit decision from the Supreme Court about the Commerce Clause and what you're talking about here, which is whether there's a positive conflict such that a state law could be struck down. The courts have interpreted that positive conflict language to mean this. Whether, and this is what we argued in San Diego, in the San Diego County case, and we were successful, that unless, and I think Alex made reference to this earlier, unless the law, the state law, requires someone to do something that violates federal law, there's not a positive conflict. There may be inconsistency, there may be a practical conflict in the layperson's terms, but as for the question of would the federal government be able to successfully have the law stricken or enjoined because of the supremacy clause, I think not so long as, well, and particularly, and I think there's an important distinction to make, what the Kreit decision means is that the federal government can still come in no matter what the state law says and arrest people and charge them in federal court and prosecute them and put them in federal prison for engaging in activity that is clearly permissible under state law. That they can do. But what they can't do, in my opinion, is go in and get a court to say, those laws that California has passed are no good, they're invalid, they're struck down. And let me suggest something to you that kind of helps me understand this a little bit. The federal government can't require the state to